Hey, Paul Rabley here. I'm an estate planning attorney, and I'm here to talk about how to amend, modify, or revoke your revocable living trust. So across my state, Louisiana, and really across the country, many people, millions of people have set up revocable living trusts in an attempt to simplify their estate settlement when they pass away. The thought process is if things are in your name, they're frozen when you pass away. Your survivors have to hire lawyers, go through a court process, attorney involvement, delay, expense. So many people, in an attempt to avoid that, they establish what we call their revocable living trust. Things in a trust when you pass away don't have to go through that court process. It simplifies the estate settlement. So occasionally, sometimes people set up their living trust, and in their trust instrument, it's dictated who gets the trust assets when they die, who's going to be the trustee in charge of those distributions. So the trust really replaces the will. Sometimes family circumstances change after someone sets up their trust and they want to either amend or modify or revoke their trust. How do you do it? Well, let's first talk about what kind of amendments are typical. Sometimes people want to amend who they designate as the beneficiaries of their trust. Maybe they said, I leave everything to my 3 children, or the 3 children are the principal beneficiaries of my trust. They will receive the trust assets when they die, and they change their mind, and maybe they want to leave something to the grandchildren or some other third party. So that's a potential amendment. Sometimes people want to change how they leave assets to a beneficiary. Maybe in their original trust, they said, I don't want that beneficiary to get his or her portion in a lump sum. I want to make sure it's doled out to him over a period of years. And maybe the circumstances change where now the person who set up the trust is saying, let them have it. They've shown some maturity. Or maybe someone wants to change who the successor trustee is or trustees are of their trust. Who's going to be in charge of that, distribution of assets to the beneficiary. So those are common trust amendments. So how do you change it? Well, what you don't do is you don't pull out a pen or a pencil and just start writing on your trust instrument. Probably worth mentioning that in our Louisiana will law, there's some really kind of sneaky and tricky provisions on how certain will provisions can be revoked and what it takes to amend a will provision in one of the forms of a will prescribed under our Louisiana law. But there's different videos and different information on changing a will. We're talking about changing in a trust. And really, it's written in our trust code what the requirement is. In fact, what it says in our trust code is a modification, division, termination, or revocation of a trust shall be by authentic act or by act under private signature executed in the presence of 2 witnesses and duly acknowledged by the person who makes the modification, division, or termination, or by the affidavit of one of the attesting witnesses. It's a lot of words there, but I will tell you that most trust amendments are done by authentic act. You say, what's an authentic act? We got to go to another book. An authentic act is a writing executed before a notary public or other officer authorized to perform that function in the presence of 2 witnesses and signed by each party who executed it, by each witness, and by each notary public before whom it was executed. So that's your typical trust amendment. Many legal documents, real estate transfers are done by authentic act. It's all typed up, special language in there, signed by the person who's making the trust amendment, notary, 2 witnesses. That takes care of it. Yeah, we do have this provision which allows for changes to be made by act under private signature, but that's a little more complicated. Authentic act is the way to go. I will tell you also that we have a provision in our trust code that says a modification or revocation of a trust may also be by testament. So don't see that much when people incorporate an amendment to their trust in their will, don't see that much. So Authentic Act is the way to go. Make sure you get some help. This is not a do-it-yourself item. Get some help. Get it done right the first time. There's a lot of wording, a lot of formalities that have to be met and done just right. So find an attorney in your area or someone you can work with who's knowledgeable in trusts and amendments and all the formalities, and just get it right the first time. The consequences of not getting it right are really things being messed up when you pass away. You can't fix it then. It could be an error that could cause, many hundreds of thousands of dollars, if not more or less, in going the wrong way, and really could cause some relationships to turn sour. Again, you don't know you made that mistake until it's too late. So make sure you work with an attorney and get it right the first time. I'm Paul Rabelais. Hope that helps in your discovery process of how to amend or revoke your revocable living trust. Y'all have a great day.